Hi there, I'm Christy Jump, and I'm here to speak with you today about worker status, determining whether your workers are employees, independent contractors, or volunteers. And unfortunately, that does not just depend on what you call them or they call themselves. So, a worker by any other name, let's go ahead and figure out who's who. First of all, the reason that you care. You care because of vicarious liability if you are an employer. And vicarious liability is the legal doctrine that assigns liability for injuries to a person or an entity which did not directly cause those injuries, but has a legal relationship with the person who did or entity who did. So what that means, translated out of legalese, is you can be held responsible for the actions of your employees and sometimes your other workers as well. This arises in the context of employment if a worker is injured on the job and the employer, the company or entity can be held liable for the actions of the workers. Now, there are some things that come into play here that we'll talk about, like workers' comp, but we're going to go through how this is affected, whether the individual who is doing the work is an employee versus an independent contractor versus a volunteer. So let's look at the different worker classifications. These impose different risks and responsibilities on you as the employer. An individual who does work for an entity can be considered either an employee or an independent contractor or a volunteer, depending on the duties they perform, the restrictions that are placed upon them, and how much freedom they have. So let's look at employees first. This is the biggest category. This is, regardless of how you label it, what most people are. Employees and independent contractors perform similar functions, but there are some important distinctions to keep in mind. These are the factors that demonstrate an employee's status. If a company has control over what the worker does and how he or she does the job, if the company withholds income tax from the employer's paychecks. Now again, you could be doing that wrong too. So please do not think that failing to withhold income tax, or if I just give them a 1099 and I don't take taxes out of their pay, then I'm good. That means they're an independent contractor. It does not necessarily mean that you're good. And it does not necessarily mean that that person is an independent contractor either. So only do that if you're sure by the other factors that the person is not an employee. There could be a written employment contract or employment agreement, even if it's not for a set length of time. Bear in mind that that could also mean a job description, the job ad that you placed in the paper, however the person came to you. The worker receives benefits like pension, insurance, vacation. Only employees get that. And does the company own the tools that the worker uses? Now, tools can mean, in the more traditional sense, a workman's tools. They can mean, things that would be on a tool belt, hammer, nails, etc., those sorts of things. But more specifically, they can also mean the computers, the vehicles that are used, the equipment that's used. So if employees are bringing in their own laptops and if workers are working off their own laptops that they've paid for and provided for themselves, they're more likely to be independent contractors. But if people are coming to the office and using company-owned equipment like a desktop computer that stays at the office, you very likely have an employee there. And the extent of control that the company exerts over the work that's done. For an independent contractor, these are things that will show that that's an independent contractor instead of an employee for the work being done. Independent contractors have greater independence in the outcome of the job and how it's done. So generally speaking, with an independent contractor, you hire that person to do a task and you give them a deadline and you kind of don't care how they get there. They may advertise independently or to the general public, and they could be working for your organization and for several other organizations at the same time. Often, this comes up in our current work environment with tech employees. So you may have a tech service that you use, or an IT individual who does some work for you, does work for other entities as well. You don't really control that person. You only pay for their time as needed. They provide their own tools, materials, and their own facilities, usually, for an independent contractor. And they do not receive benefits from you. You don't pay their health insurance, anything like that. And they have not signed or likely even received an employment contract or a handbook. Now, you probably want to have an employee handbook. You probably want to have an employee handbook for every individual who performs work for your organization, and you can have a written agreement of the work to be performed, even with independent contractors and volunteers. They just have to be very different, and they have to specify who has control over what things you are controlling versus what things they are controlling. And then let's look at volunteers. Okay. Volunteers are individuals who provide services without any promise of compensation. They are necessary and essential, especially during times of crisis, but they do pose a risk to individuals as well, or to organizations as well, to employers. So you can still be held responsible for the actions of your volunteers. So you want to be careful with that. They are important, they are necessary, they still matter. So let's look through the hiring process. This is another way to assess whether a worker is an employee or a contractor or a volunteer. How frequently is the work performed? If this is something that is performed 5 days a week, day in, day out for approximately 40 hours a day, far more likely that you got yourself an employee or at least an independent contractor. Who has control over when and where and how the work is done? Do you tell the person that they have to begin work at set hours and end at set hours? Do you tell the individual where they perform the work? Again, that doesn't necessarily mean that the person is not an independent contractor or even a volunteer as far as where the work is performed, but it does have a pretty strong bearing. It is a factor in determining whether the individual is an employee. And do you control how the work is done? So again, with an independent contractor, you generally are going to give that person a task. You're hiring them because they have expertise in that area of what you need, and you give them a completion date. For the most part, you're paying them a set fee, or you're paying them like a day rate or a monthly rate, and you don't care how they get it done. That's, again, your independent contractor. Are others paid for the same work? It is extremely hard to make a good faith argument that you have employees whom you pay and volunteers whom you don't, who are performing the exact same duties. Chances are those volunteers are actually employees, and you may owe them wages if you are paying other people to do the same thing. And is this person paid for other work by the same entity? It's really hard to have your own employees do volunteer work for you. It's possible if it's drastically different situations, drastically different duties, but it is very difficult to have your employees also be your volunteers. Then you'll look at who provides the tools that are necessary for the work to perform. Again, independent contractors tend to bring their own tools. They'll be in charge of their own resources. They'll be in charge of what they have, what it costs, those sorts of things. You may have a checklist where you require that they have certain things or that they show you that they have the right tools. But if you are providing them, if you are saying use the company computer, with the possible exception of IT people who are coming in to make sure that your systems work, it is quite likely that if you are requiring that they use company provided materials like computers, that you probably have an employee. Would you be mad if the person subcontracted out part of the work? So you've hired this individual to do a task, right? And you want that task completed. Well, what if out of the money that you pay them, they paid somebody else to do a portion of it? That's what an independent contractor quite likely will do. An independent contractor may subcontract out the work. You can have an agreement that they not do that, or that a subcontractor has to be approved by you in advance, the use of a subcontractor, but that the amount paid would still come out of the total fee. But in an employee, you're not going to allow to do that. You don't let your employees farm out their job duties to other people that they choose to hire, even if they're hiring them as independent contractors. So if you won't let them sub out the work or even parts of the work, then you probably have an employee as well. Now, here's a question that I referred to earlier regarding whether the person is paid for other work by you, and the fact that it is very difficult to have your employees volunteer their time for you. Can employees volunteer to work overtime and therefore not be paid for those additional hours? Absolutely not. Nice try, but absolutely not. Not even if they put it in writing and sign it and agree to it. That's extra bad because you just provided proof that you're trying to get around paying them overtime. People cannot volunteer, your employees cannot volunteer to do their jobs. If it's taking them extra hours, but they're doing the same things, then you owe them overtime. They are working and they need to be paid for that. Why do we care about this? Why does it matter what you label them and how you pay them? It's that liability thing again. You want to stay out of liability and not have to, first of all, end up getting in trouble with the courts or any agencies down the road, but also not being held responsible for things that you didn't think were your responsibility. Employers are responsible for the actions of their employees as long as those actions occur within the course and scope of their employment. So basically, if they're doing what you hired them to do, then you're responsible for their actions as they do that. Independent contractors, generally speaking, you're not liable for the actions of an independent contractor unless that contractor is engaged in an inherently dangerous activity for which you hired them as your contractors. An example would be transporting or handling explosives, working with wild animals, things like that. And if you hired them for that function, then you may still be liable for how they perform that function. But generally speaking, because you're not controlling how the independent contractor does the job, you're not going to be responsible for what happens when the independent contractor performs that function. Now, for volunteers, you can be responsible, organizations can be held responsible for volunteers' actions if they're occurring within the scope of the volunteer's duties. Courts will look at a couple things. They'll balance the degree of control over the volunteer, the scope of the volunteer's position, and the benefit that the organization gets from the volunteer's services. And so that's a balancing act. There's not a clear, I can't give you a clear mathematical formula for those. Just understand that the higher the degree of each of those, the higher the likelihood that you'll be held liable for the actions of a volunteer. Let's look at risk management for volunteers. How can you minimize that? Because a lot of organizations do need volunteers. Insurance policies will provide some protection, but your organization also needs to have something else in mind too. An effective risk management plan should include these things. It should reduce the risk of harm to volunteers and the individuals that they serve. So figure out how you can predict things that are likely to come up. Slip and fall situations, injuries by, if they're working with needles, injuries by working with needles, the risk of financial loss to volunteers and the organization that they volunteer for. So maybe that's insurance, maybe that's where you get waivers from the other people that you work with or that you perform the services for. And to reduce the risk of damage to the organization's reputation, partnerships, ability to recruit new volunteers, and ability to raise funds for their operations, you want to make sure that you have clear understandings and clear agreements in place. Saying, for example, these are volunteers, you won't be paying them, you train them on what they're going to do. You can require that volunteers go through volunteer training, and then they have to perform whatever they're going to be doing for you in accordance with that training that you've provided. That also puts the organization in a better place because you can say that you did your best to educate them on the safe ways to do things. As far as selecting volunteers, you want to, again, adequately recruit and train and screen volunteers to make sure that they're suited for the roles. We do recommend that you do basic background checks on all the volunteers. You can hire outside agencies to do that for you, or you can run a search through publicdata.com or a service such as that, if that's something that you prefer to do. But you should do at least a basic background check on anybody who's going to be performing services for your organization. Provide recruiting materials that will help the volunteers determine whether this really is a good fit for them. Make sure they know what they're signing up for from the beginning. And prepare the volunteers for the roles that they're going to be performing. The better prepared they are, the less likelihood that there's going to be any unintentional harm. They need to know what they should do and should not do. They need to know what's likely to come up because you've had people be in this situation before, even if it's the first time that this volunteer is performing those duties. Your agency's volunteer position has to have an accurate description, a code of conduct, training, and practice exercises. You got to give them some sort of a dry run. You got to have them do some sort of a practice so that you're not just throwing them out there and saying, good luck, and we're just going to cross our fingers and hope that all goes well. And again, provide training and as needed protective equipment, and make sure that they sign waivers and informed consent forms. It'll help lower the risk to all. Also, people remember if they signed a waiver or an informed consent form, and then they'll be a little bit more on the lookout for maybe any dangerous situations they might be able to avoid. You want to document your recruiting and your screening strategies. You want to make sure that you have your code of conduct written out and that everybody who performs work for your organization has signed off on it, and that you have your training process written out. You want to clarify which actions are going to warrant dismissal. You can and sometimes need to fire volunteers as well. You don't have to keep them forever. Clarify the expectations of how your volunteers are supposed to behave in situations that they might encounter. Again, yeah, you know what's going to come up in performing the job duties for your organization. They may not. So make sure that you make that clear. All right, well, what about your employees? How do your employees and your volunteers interact? Volunteers pose a degree of risk on employers because they typically don't have significant training. The employer generally does not exert the same degree of control over them, like we just talked about. But what about the same risk management strategies that we talked about? What should apply to your employees as well? To begin with, you want to make sure that your job postings are accurate. Your job description, your search for a position is going to serve as your actual formal job description, even if you think you don't have any. If you posted an ad looking for a worker, that's your job description, unless you come up with something else. You want to have a thorough screening process. Again, at a minimum, just a basic background check. Clear expectations that you have communicated. You want to train people, train your employees and your volunteers. And you want to have the employee handbook and code of conduct that is available and provided to them, and that they sign off as having received. You also want to have an appropriate level of oversight to make sure that once you've gotten all these good plans in place, that they're actually being followed. And you want to take swift disciplinary action when it's necessary. It's great to have all of these things in place and go through notifying everybody about them and have them sign off that they've received them and have a supervisor. But if nobody's enforcing the rules, then it doesn't matter that you have the rules. So you need to make sure that it is being enforced and that people can see that this organization cares about making sure that the rules are followed. All right, we're going to go through two examples here of when this came in front of the courts to determine whether workers were employees or contractors. The first one involved Microsoft, and this was, I think, about 10 to 15 years ago. Microsoft learned the lesson the hard way. Microsoft had hired a big pool of workers with the title independent freelancers, and these individuals did not receive health benefits. They were theoretically hired only for specific projects, and they signed agreements saying that they recognized that they were independent contractors. All good, right? However, Microsoft treated them like employees, integrated them into the pool of regular workers. They worked normal employee working hours, and they performed identical functions that the employees did. 8 of them sued Microsoft, alleging that they were entitled to full benefits. This came down because of health insurance. That's what triggered this. And they said that the time that they had been treated as independent contractors, they should have been treated as employees and then, therefore, given health benefits. And they won lots and lots of millions of dollars because this applied to a lot of people who are in that position. Although only 8 of them sued, it applied to the entire category of workers, so that entire description. The lesson here is that the individual's title, even if they sign the agreement, is not what matters the most in the eyes of the law. What matters is how you treat the worker and the work that they actually perform. And not paying attention to this warning can end up being extremely costly. So we hope that no organizations end up in the same situation that Microsoft did with that topic. Now let's look at the other side with Uber. Uber came out on the other end of this. A federal judge ruled that drivers for Uber were in fact independent contractors and not employees. So let's look at what's different here. The company has strict requirements for driver conduct. And so what the judge looked at were these factors. The right to control. Uber does not exercise control over its drivers. They had strict requirements for conduct, but you drive your own car. They don't care what kind of car you drive. Profit and loss was at the driver's control. They were in charge of their own hours. They were in charge of when and where they drove, as long as they were communicating availability. Generally speaking, the drivers used their own personal vehicles with very rare exceptions. And They didn't have to have a particularly unique skill. Having a driver's license is not something that is considered a special skill. So that supported independent contractor status. And the relationship was not permanent by any means. Uber drivers have complete freedom to end the relationship whenever they feel like, and to create their own work hours so they can work more or less. And Uber doesn't require that they work, for example, 40 hours a week. So all of that weighed in Uber's favor in finding that these workers were independent contractors. Why does that matter? Well, historically, when courts look at misclassification of workers, they almost always rule in favor of the employees. And so this is a break from that trend. This also shows that the court doesn't just look at the job titles or agreements. Otherwise, Uber would have won just based on the title alone. Now they ended up winning, but not just because of the title of their workers. The courts really do look at the specific facts and the duties that are performed. So they look at the actual work performed and how it's performed and the conditions under which it's performed. All right, I do want to thank you. Again, this is a big topic that has a lot of subsets to it. So this is just an overview, as with many of these recordings. But hopefully this has given you at least something to think about, if not some helpful information to take as you move forward and to put into your own use. If you want to reach us, you certainly can at CLCMA.org. And again, my name is Christina Jump, and I am the Civil Litigation Department Head. You can reach me through our website as well. And I thank you for joining us. And I want to wish everybody stay safe and stay informed. Thank you very much, and have a good rest of your day.